Hello everyone, I am Shivantika, legal intern at LEXIS and Company for the month of June. And today in legal news, Karnataka High Court observes that personal laws will not override POSCO Act. Child Marriage Restraint, that is the Child Marriage Restraint Act. The Karnataka High Court has said that though second marriage is permissible under the Mohammedan law, but the personal laws cannot override the special law of POSCO, Child Marriage Restraint Act, and General Penal Code of this country. A single bench, while dismissing the bail application filed by the accused Rahul, said that merely because the parties are Mohammedan does not mean that the petitioner accused number one has the right to marry a minor girl by enticing and abducting her. The consent or the will of the victim minor girl is immaterial, and even if she has voluntarily went with the accused, this amounts to abduction or kidnapping under the section 363 of the IPC, and the accused not only abducted the victim minor girl who was aged about 15 years, he also got married to her, which attracts section 9 and 10 of the Child Marriage Restraint Act. Apart from that, he also sexually assaulted her, which also attracts section 4 and 6 of the POSCO Act. So the court turned down the no objection given for the bail to be granted to the accused by the victim. The court opined that the age of the victim being 15 years, her capacity of understanding cannot be at par with any adult person who has completed the age of 18 years. Therefore, even otherwise, if she has given her consent for the marriage or the sexual intercourse, her consent is basically immaterial as she is a minor. Further, the court also noted that the respondent number 2, the complainant who appeared through an advocate and had produced an affidavit of the victim stating that the victim herself went along with the accused and got married. She is residing in the house of the petitioner accused. The court said that it cannot be taken as her consent for granting the bail, even if the victim stated no objection. But basically, she is a minor girl. It cannot be considered as a valid no objection as it is against the law. Further, the court also observed that the victim had made her statement under section 164 of CRPC. She has categorically stated that they threatened her to marry. The accused has taken her to his first wife's house, that is accused number 2, and there is where is there they had sexual intercourse. Section 164 of the CRPC is foremost important for considering the bail petition of the accused. Even if a minor girl gives no objection to basically release the accused in a heinous crime or rape of a minor girl, and granting bail to the accused is nothing but giving license to the offenders to commit similar offences, which would dilute the special act enacted by the parliament for protecting the children from sexual offences, also deviating the provisions of section 9 and 10 of Child Marriage Restraint Act. The court also added that apart from the provisions of section 375 of the IPC, it will send wrong message to the society. Therefore, in the interest of the public at large, with an intention to curtail such type of sexual offences, the court shall ignore the consent of the minor girl, giving no objection of granting the bail to the accused, and the court should deal with such heinous offences with an iron hand. Therefore, the session court has rejected the bail application filed by the accused, following which he approached the High Court. And this is all for today in legal news. Thank you so much.